Dakota is now in session.
Good morning, please be seated. We are here at the time set for oral argument in file number 2026-0005, Casey Michael Baumgartner versus the North Dakota Department of Transportation. Sitting this morning are Justices Jared Tufte, John Jensen, Douglas Barr, and Mark Fries. I am Lisa Fair-McEvers. Arguing for the appellant this morning is Chad McCabe, and for the Department of Transportation, Mr. Michael Pitcher. Mr. McCabe, when you're ready, you may proceed.
May it please the court, Mr. Pitcher. So this case, I understand, has a strong deference to the findings of fact made by the hearing officer. But the reason I appealed this, Your Honors, is the hearing officer didn't reject any of the facts that were presented, and we did present competent medical testimony that Mr. Baumgartner was not able to answer even simple questions. And that is in the record. The hearing officer did not include that in her findings of fact, which I found a little surprising, but she did not ever make a finding they weren't credible. I mean, those are the facts. The facts are that the nurse practitioner that was in charge of Mr. Baumgartner testified that he could not answer simple questions. And of course, those simple questions were, will you take a chemical test? Will you take a screening test? And so I can't tell you how hard it is to get medical testimony on a case such as this. I mean, we're usually just having clients testify, police officers testify. I mean, this case is really unique that I had medical testimony from the hospital saying that Mr. Baumgartner could not answer simple questions. And that when the officer was asking those questions, that's when the medical personnel was there. Now, the hearing officer seems to take the information that Mr. Baumgartner was, out on the scene saying that he was the driver. That's at a different time, a different period where the medical personnel weren't there. I think for this court to look at these facts, the critical facts are what was going on when Mr. Baumgartner was being asked to take the tests.
Mr. McCabe, aren't the critical facts that he did actually articulate the same answer repeatedly to the same question? So to say he could not answer, the facts show, according to the officer's testimony, he did answer.
Well, Mr. Baumgartner, sure, I agree with you, Justice Barr, but Mr. Baumgartner also testified, and again, he was not found to be not credible. He testified he had no recollection of this.
Yeah, but that doesn't mean he didn't know what he was doing at the time.
Well, if you don't remember, and again, usually I'm facing this court where you don't remember and you have no medical testimony to corroborate your client's testimony. I mean, here I do. Here I've got the medical testimony. I mean, in 30 years, this is the first time I've actually been able to get a medical personnel to come to one of these things and testify. So they don't want to testify, they don't want to participate. Usually it's the officer and the individual. And I've read so many court cases where, well, if you would have had medical personnel, well, finally I got one, and here I am still fighting this case. I was shocked I lost this before the hearing officer, I'll be honest. I was completely shocked.
Mr. McCabe, the medical personnel did not answer the question of why your client had difficulty answering the questions. It might have been obstinance, it might have been gamesmanship. There's no connection from the testimony that the injuries or circumstances of his hospitalization rendered him incapable of consenting.
I would disagree, Justice Fries, because she did say he was unable to answer simple questions. I think that says it right there. He was unable. It wasn't, I don't think we have to know why or how. Plus, we have pictures of him sitting in the hospital. They're looking at his brain. I mean, I've submitted all those pictures. I mean, he's laying in the hospital. He's being treated by medical personnel.
Did he consent to the medical treatment?
I have no idea. I would say probably not if he was incapable of consenting, but I mean, they treated him as they always do.
So did the medical person testify that they contacted someone else because he to authorize the medical center to provide the treatment because he wasn't able to authorized by his own consent?
I have no idea how that took place. They took him in an ambulance to the hospital and started looking at his brain to see if everything was okay.
Mr. McKay, maybe I'm being too direct, but this is a question of fact, right? I mean, there's no error of law that the administrative judge applied. It's a question of fact.
Well, it is a question of fact to some degree, but I would say that there's no facts to support the
Right,
hearing.
and that kind of gets to my next part.
Yeah.
I mean, the fact that he said no, and said no repeatedly, again, might be some evidence that to support a finding that he had said no. I mean, at the end of the day, isn't your argument, we should be left with a definite and firm conviction a mistake was made based on this evidence? I mean, that's where we're at.
Yes, and I think you get there by just reading the transcript and
Right.
seeing the testimony.
But ultimately, at the end of the day, I'm not suggesting I don't agree with you, or the court doesn't agree with you, or the court does agree with you. But at the end of the day, that's our question. Should we be left with a definite and firm conviction a mistake was made, based on all this evidence?
Yeah, I think it's a legal question to some degree, but it's based upon the facts as presented. So I do agree with you. But I think the hearing officer ignored my testimony. She didn't find that it wasn't credible. She just ignored it and decided to lean on the fact that my client said he was a driver of the vehicle, and that, as we've been talking about with Justice Barr, that he did answer questions. He has no recollection of it. But this court made a statement in the cases I've cited that, there's no competent medical evidence. I have competent medical evidence. So I've provided that to you. He did not remember, he testified. Then the hearing officer says that he did not impeach anything by testifying he doesn't remember. I would respectfully disagree. I think he did impeach that issue by saying that he did not remember. That's usually all we have is our clients.
So, counsel, could he have been competent at the time the questions were asked, but because of later medical procedures, later whatever, he doesn't remember it? There's not an exact connection between what I remember months later and whether I was competent at the time I was asked the question.
Well, you have his testimony, which was that he does not remember anything at the hospital at all. You've got pictures of him laying in a hospital bed with nurse personnel, and that's from the officer's body cam, so we know the officer's standing there. And we know that that's about at the time that the officer walked up and then asked these questions, will you take a test? We also know that just before that, you've got pictures of they were looking at his brain. And then you've got the testimony, again, I think the most critical, from the treating person in charge medically saying that, again, this is not even in the hearing officer's decision. She states he was unable to answer simple questions. I don't know how we get around that. That's a finding of fact that was ignored and is so significant, because how do we then determine that he consciously said no if he was unable to answer a simple question?
In this case, is the finding reviewed under that reasoning mind reasonably could have concluded standard rather than the usual clear error standard?
I guess I'm not sure of the difference on the difference.
I'm not totally sure either, but I don't know if we've broken down the reasoning mind reasonably could have concluded into definite and firm conviction or no evidence to support, or if we've broken it down the same. Do you know?
I do not know. I usually just use the language from the Supreme Court, so I make sure I'm quoting the court correctly. So I know that I've used that language from your cases that, a reasoning mind could not find this, but it seems to me that this hearing officer is taking the fact that he was able to talk to an officer early on in the process, way before going to the hospital, and then taking these statements that Justice Barr's talked about, which, yeah, he does make the statements. Reading his responses, he gives a rather bizarre response about an STD. But again, the question is, was he able did he and again, the statute that when someone is unconscious, I understand that no longer exists, but I think we're still dealing with a situation where we have to look at the facts, and this court has recently, in the two cases I cited, did the person refuse? Was the person capable of refusing? And I would say that in these facts here with medical personnel, and we know the officer asked these questions while she was standing there with medical personnel, while there was also an admission by the officer of distractions. There was distractions going on. So you'd take that all over. Can the hearing officer make a finding from all that Mr. Baumgartner could respond to those questions? I submit to this court, no. I submit there is not enough findings of fact to support that. The findings should go the other way. A reasoning mind, Justice Tufte, should not find from the facts I presented that Mr. Baumgartner was capable of saying no. And I guess that's where I'm relying on. I'm relying on this I'm relying on my client's testimony too, that he doesn't remember. But I mean, the more important, the more significant is that these officers the one officer asked these questions while the medical personnel was standing there, and the medical personnel testified as to what we've talked about. Those are my big issues here. I know it's a strong deference, but this court has found, based upon, I would say, weaker facts, that the person was not capable of refusing. My facts are stronger than the last case this court found, that the person was not capable of refusing.
I don't mean to quibble, but
Sure.
hopefully we didn't find, but did we either reverse or affirm in those cases?
You affirmed, you affirmed a district judge.
Right. So we weren't finding, we were affirming a finding that a reasonable person could reasonably conclude.
Yes, but this court, in doing so, said there, I'm going to the other case now, there was no competent medical evidence. I mean, I think we have competent medical evidence here.
And I'm taking a look at the transcript right now, Mr. McCabe. So did Ms. Lopez, the nurse practitioner, actually testify that he wasn't competent to consent? She makes some kind of tiptoey statements in the part that I'm reading about him being altered or.
She does use the word conscious, unconscious. I forget that I put them in black on my brief, but
Does she ever say at the time that he was asked to consent, he was incapable of consent?
well, she makes just a general statement that he was incapable of answering simple questions, and she doesn't state when, but it's during that
But doesn't that timing matter? Was she in the room when the officer requested this?
Yes, I established that.
So she should have been able to say yes or no in your medical expertise. Was he capable of consenting to that? And I didn't. I'm still looking through to trying to.
No,
look
I
at it
didn't ask that
closely.
specific
Okay.
question, but I tried to establish a picture of the events. Were you there? Was the officer there? Yes. Was Mr. Baumgartner, I don't know if I asked her or she just responded, but at some point she said during that process that was going on, he was not capable of answering simple questions. I don't think we have to have a play-by-play of each little question. I mean, Miss Lopez knew her reason for being there. She was there to support him because she felt that he didn't refuse. And I didn't ask that specific question, but, because we were trying to lean towards medical questions. How was he? How did he appear? Could he respond? And I thought that was enough, but here I am.
McCabe, you indicate that this is a kind of a case of first impression, that there was more medical testimony. I reviewed Mayo again over the weekend. How do you distinguish this case from Mayo versus Moore? Because I see the testimony in Mayo to be more direct to the question as to whether the person could consent or not.
And I apologize, I'm not familiar with Mayo versus Moore. I had the two cases this court dealt with was Polinsky and Pavlik, I believe. I will take a look at Mayo versus Moore if it's referenced.
Then how about Pokorinsky? How do you distinguish this from Pokorinsky?
Well, I just, again, neither case had medical testimony that I'm aware of. So in this case, we've got credible medical testimony. I think that's the difference. I mean, usually it's an officer, usually it's maybe sometimes the driver that's testifying about things. And I think in the one case, it's one of the two, the driver said he heard something from somebody and that's how he testified about it. We've got the actual testimony here from the treating person.
As did the hearing officer in Mayo.
Okay. All right, I am not familiar with that one. I'll have to look at that. Does the court have any other questions? Okay, thank you very kindly.
Thank you, Mr. McCabe. Mr. Pitcher, you may proceed whenever you're ready.
May it please the court, counsel. As Mr. Baumgartner has argued, this case is about deference to a reasonable agency decision. The hearing officer found that Mr. Baumgartner refused chemical testing, and under the standard of review, that finding must be affirmed if supported by a preponderance of the evidence. The evidence is fairly straightforward here. Baumgartner was conscious. He was responsive and communicating with law enforcement. He was read the implied consent advisory and asked to submit to a chemical test. He said no repeatedly multiple times, and he gave a reason for that refusal. The appellant's argument asked this court essentially to reweigh the evidence and act as a superboard and substitute its judgment for that of the hearing officer. The hearing officer reasonably found capacity and refusal, and the district court correctly affirmed, and this court should do the same. Now,
one of the facts that you listed as supporting a finding that he had the ability to consent was that he gave a reason for saying no. And what was that reason?
he indicated that he didn't want to take the chemical test because he didn't want to get an STD.
And my question is that a rational reason for not taking the chemical test?
Well, number one, whether it's rational or irrational, it's still shows comprehension.
Does it though? I mean, if he would have said that because something completely ludicrous and absurd, would that still indicate?
Well, certainly if it's totally ludicrous and absurd, I might agree with you, but this is
Because I'll turn into Mickey Mouse.
Potentially.
How close is I'll get an STD? Is it closer to a rational response or is it closer to an irrational response?
My response to that is I've been doing this for a long time with all these cases. This isn't the strangest response I've seen. Obviously, a STD was understood by both parties as a sexually transmitted disease, and certainly you have STDs that can impact not just the genitals, but the oral cavity. So you have herpes, for example. You know, I don't know what was in his mind, but this could be that I don't want to blow on a device because it was first asked to give a PBT, and so maybe he's thinking, you know, there might be some way I'm going to get some infection in my mouth. And so in that sense, it's less than the Mickey Mouse. That is more rational, but I I certainly concede that that's not usually the typical answer, you know, but I think it's closer to a rational response than a totally ludicrous example. And so it is a decision, and it showed decision-making. In fact, he said, it wasn't just that I'm going to get an STD, but someone once told me that. Okay, so he's providing more conscious response. The appellant's argument is that I think they rely too strongly on Ms. Lopez's testimony. Ms. Lopez indicated that Mr. Baumgartner had difficulty answering medical questions, especially about clearing the C-spine. She did say that he had trouble answering simple questions, but it was directly related to clearing the C-spine. And the only specifics that she could give is that he couldn't respond about his pain level. She did not say that he couldn't understand the officer. She did not say that he was incapable of refusing chemical testing. And the timing here was not really set forth at the hearing. We don't know when she was speaking to Mr. Baumgartner versus when the officer was, if one was before the other, how much time interceded, what was going on. But it is clear that Mr. Baumgartner was conscious this entire time.
Mr. Pitcher, I'd like to ask you the same question I asked Mr. McCabe, and I pulled up Mayo. It said that the psychologist testified at the hearing and said that Mayo was unlikely to make a knowing and conscious decision about taking the preliminary breath test and the chemical test. How do you compare Mayo to the facts that were before this hearing officer?
Mayo is a much stronger for that reason. You've got medical testimony that's directly saying about the capability of the motorist to respond to the officer's question about refusing testing. That's one thing that's here is, in fact, in Pokrzynski, this court cited a Minnesota case where you said that the trial court's finding that an officer had no indication that the driver was physically incapable of refusal at the time of invoking the implied consent law will be affirmed if there's adequately evidence to support it. It's the idea that the officer, what did Deputy James know? Certainly we have testimony at this hearing from Ms. Lopez, but she's not speaking to, there's no communication that we know in the record between the medical staff and the officer. If they're there at the same time and she's concerned about his responses at all, why is she letting the officer talk to him? And not, at least not instructing, like I wouldn't trust what he's saying, there's none of that. And she did not testify directly that he doesn't have the capacity to respond to you and make a decision as it relates to preliminary breath testing, chemical testing, or otherwise.
Then my next question is, should this court give the level of deference to this finding that it does, right? The hearing officer had the opportunity to cross-examine the petitioner's expert, didn't ask the relevant questions, and made findings that supported a decision for the agency for whom she works. Is that level of deference appropriate?
Well, I would disagree with the counsel's argument that there was no, that the hearing officer did, in the decision, look at the decision, she cites to Ms. Lopez's testimony several times, so she is taking it into account. She's not just rejecting it outright as what's been suggested. I don't know if that's answering your question, but I think the officer is weighing the evidence and is understanding that there's no basis from the testimony of this, there's no medical testimony directly related to whether Mr. Baumgartner is mentally incapable of making decisions. In fact, that C-spine stuff was all about, the spinal cord, physical ailments, not necessarily mental ones. There's a suggestion that there's a picture of showing a brain scan. Well, yes, we know that he was taken for CT scans and an X-ray, but medical staff often do certain procedures to rule things out. We don't know if they found anything. Just because they're looking at a CT scan doesn't mean that there's any impact on Mr. Baumgartner's brain functions or ability to refuse chemical testing. There was no testimony directly related to that, and I think that's why this court needs to give deference to the fact finder that his listening to both of the evidence and is making a reasoned decision. Again, Ms. Lopez did not testify that Mr. Baumgartner was incapable of understanding the officer. She did not say that he was unable to communicate, like was the case in Packenow, State versus Packenow, the most recent case that this court decided. This case is more strongly in line with the Pokrzynski line of cases than it is the Packenow type of cases. In both Pokrzynski and this case, the driver, after the fact, could not remember anything about the accident or being at the hospital whatsoever. In both of those cases, the drivers were conscious and communicating, unlike Packenow, where the person was in and out of consciousness and then was intubated, not able to speak to medical staff or the officer. And so we think that this case is more in line with Pokrzynski than it is the Packenow type of case. Again, the decision that he made was repeated, it was verbal. This does not show incapacity. that shows the decision being made by Mr. Baumgartner. And, you know, I think it's for that reason that there was evidence for this hearing officer to make the finding that she did. And I think under the deference standard, this court needs to affirm that. Unless there's further questions, that's the department's argument.
Mr. Pitcher, I have one question, and so there's a list of 8 things that we need to be looking at. The court must affirm the agency's decision unless, and then it lists the 8, and I won't repeat them because you've probably written them 100 times in your briefs. So which portions of that do you think Mr. Baumgartner is challenging? Is it just 5 and 6?
Yes, he's challenging the findings of whether
and the conclusions. Is it the findings and conclusions? Is that?
Correct.
Just to simplify?
That's
nothing else?
Not that I'm aware of, Your Honor.
Thank you.
Is the implied consent given by driving doing any work in this case? Because it seems like somebody who lacks capacity to refuse would also lack capacity to withdraw consent already given. And structurally, how does that work here?
Well, that's the interesting thing is if the district court and even the hearing officer, of course, the argument by Mr. Baumgartner was in line with Pokrasinski and Packenow when this court had a different statute in play that has since been repealed. And so then the question is, what do we do with that repealing of that statute that said any person who is dead, unconscious, or otherwise in a condition rendering the person incapable of refusal must be deemed not to have withdrawn consent. That's now been repealed, and so I think we go back to the standard. The standard in implied consent is by virtue of someone getting the license, they have deemed to have given consent to testing, but this court has said many times that there's legislative grace to withdraw that consent. Obviously, if the person's dead or unconscious, they can't communicate with law enforcement to withdraw that consent, but that's the difference here. I think it goes back to the standard. The consent is presumed, but it requires, even as in the appellant's brief, they indicate, according to the Groskebauer case, while consent may be the default legal position, in practice, the statutory scheme requires communication between the officer and the driver. Because he was conscious, Deputy James needed to speak to him, and he gave this conscious, responsive answer to the question after being read the implied consent advisory. He properly withdrew that consent, and then 392004 says, if someone refuses, no test may be given. And so that legislative grace was applied by Mr. Baumgartner's answer. The officer could not get any testing. This would be different if he was unconscious. Then I think they could go and get the testing done based under the implied consent law. And unless there's further questions, I've kind of answered what we're asking, that you affirm the hearing officer's decision.
Thank you, Mr. Pitcher. Mr. McCabe, you have 10 minutes. Before you get started, Mr. McCabe, I just want to ask you the same question I just asked Mr. Pitcher. Your only 2 challenges are to the findings and the conclusions of law. Are there any other of those 8 listed items that in your brief or that you have relied on that I'm missing?
I mean, number 7 would apply too, I guess. The findings made do not sufficiently address the evidence presented to the agency by the appellant, because I presented evidence that the officer was asking these questions while Ms. Lopez was standing there. And I also presented evidence that Ms. Lopez said that he was unconscious, or not, she used the word not conscious, but again, not capable of answering simple questions.
So if we agreed with you on 7, does that require a remand? If the findings do not adequately address things that you raised, do we send it back for the hearing officer to address them? That's part of my purpose of asking these questions, is what the remedy you're seeking, I think, is not a remand.
No, I just asked for a reversal. I guess I hadn't really considered that, Your Honor. I mean, that would be a potential possibility. I think based upon the evidence presented, it's just contrary to the hearing officer's decision, which is 5 and 6. But
Mr. McCabe, doesn't the hearing officer twice in the decision state that the refusals were unequivocal and then later says there was no credible evidence that Mr. Baumgartner was incompetent when he refused? Isn't that sufficient to address the evidence that you presented?
I don't find that statement in and of itself she relies upon all the testimony that I presented and never once says that testimony is not credible. And I just find it a sweeping statement at the end is saying
The
there's no
decision
credible
specifically finds that the evidence was not credible. There was no credible evidence Mr. Baumgartner was incompetent when he refused.
But if you read that the way I think you're reading it, then she's just completely ignored my witness's testimony, what's the basis for that? She never made a finding as to why she should not be credible.
Then my question to you is the same to Mr. Pitcher. Should the level of deference that this court gives be the same in this type of an appeal?
Well, it does seem a little self-serving how the hearing officer's decision was written, I will tell you that, but I would argue
You're
that.
not aware of any case that we've treated DOT administrative appeals different than any other agency under the Administrative Agencies Practice Act?
Not at this time, Your Honor.
And
but
that wasn't argued in your brief?
No, it was not. And Justice Freeze, I apologize, that Mayo case slipped me by. I didn't, so I'm not familiar with the facts of that case, other than what I've heard you talk about, Your Honor. But I did cite the most recent cases this court talked about, where, again, it seemed that this court was relying upon medical evidence, credible medical evidence. I don't know how you can say that I don't find credible evidence when you've written an entire opinion upon what my witnesses have said, not once saying that testimony is not credible. And then at the very end, just as a summary, I don't find credible evidence. To me, a hearing officer should say, why did you not find this credible? And again, we did this all over the telephone, so she can't say, well, I was watching his face and he looked up or he looked down or scratched his ear. We don't have that. This was on the telephone. So this was a telephonic hearing.
She couldn't have testified to that on the phone?
What's that?
She couldn't have testified to what she observed over the phone?
No, a hearing, I know we've had some arguments over the years on whether these hearings should be telephonic or in person, and this court has made an indication on the telephonic hearings, the concern that you can't actually visibly see the witness and make a.
I misunderstood. I thought you were discussing what the witness was testifying about.
No, but I guess what
I misunderstood,
Yeah.
Mr. McCabe, I'm sorry.
I'm just saying that the hearing officer here could not make a finding that by viewing Ms. Lopez, that somehow she found her not credible, because she listened to her on the phone as she did the officer, as she did Mr. Baumgartner. So,
What in your view should a careful, scrupulous officer do when faced with an apparent refusal of dubious competency? What's the officer supposed to do under the statute?
that is a very good question, Justice Tufte. I mean, of course, if they were unconscious, you could just take the test. I don't really know the answer. I'm not really sure what the answer is. I'd probably get a search warrant, and then you don't need to get consent. You just get the search warrant, which they had time to get, and then you just take a blood test.
Was there a body video? You said there was a photograph and evidence. Was that taken from the body video?
I took it from the body cam.
So wouldn't that have been better evidence than just a still photograph of what was going on at the time if the officer was wearing it the entire time?
Yeah, it was just complicated to get the body cam to the hearing officer because I only had 1 day or 2 days, I can't remember, and I was having problems.
Can there be any inferences made one way or another about what evidence would be the best evidence?
Well, again, I found it a little silly that the hearing officer blamed me for not presenting evidence when it's the department's burden in the first place. But she seemed to sort of make that point that because I didn't present
She should have considered it on her own. She would have access to it?
I guess she'd have to get it from the officer. She could have subpoenaed it. She had the ability to subpoena the video evidence, but given my time constraints, I just shot some pictures trying to show. And Justice McEvers, just to answer your question, I do establish in Ms. Lopez's testimony that she was there during those questions. I mean, it was happening while the deputy was asking the questions. She was there, standing there. And I know the department wants to split hairs here on these questions that I asked. Are they to medical or are they just general questions? They weren't specified as to medical questions. That was the condition he was in at the time. The deputy was asking the questions at the time. So
Mr. McCabe, there's a series of cases where this court has drawn inferences when a petitioner does not testify. In this case, where your client testified and the DOT did not cross-examine either the expert or your client in order to get to the relevant questions, should inferences be drawn against the DOT as well?
Well, that would make more sense than shaming me for not providing a video. I mean, it seems like I'm the person that got shamed here because I didn't give the video. It's the department's burden to put on this case. So,
Correspondingly, you could have had the witnesses testify in person. You have a right to do that.
I had a right to, but they much prefer these phone hearings, and I guess I've sort of fallen prey to it as well, just because it's easier. But we could have had an in-person hearing, but it would have complicated things quite a bit. Anyway, I just want to make clear that, there's no question Ms. Lopez was standing there based upon the testimony I've presented from the transcript during the time the deputy was asking these questions. It didn't happen at a different time. It was at that time. I also have pictures you can look at showing that she's there while he's there. That's when he's asking the questions. I mean, this all happened fairly quickly with the deputy walking in and asking questions. So, anyway, I don't think it's fair to Mr. Baumgartner that we're using evidence of him at the scene of the crash to somehow support that he's conscious later on in a hospital to answer questions. So, thank you.
Thank you, Mr. McCabe, for your arguments this morning, and yours as well, Mr. Pitcher. This case will be taken under advisement, as all cases are, and we will stand adjourned until 10:45 a.m.
All rise.